Yeah, yeah.
May I please, Lordship?
I think we shift. I just change my chair
Lordship.
because this chair can move left and right. So I'm supposed to have a steady chair.
Yeah.
We just get out. Yes.
May I please, Lord? My Lord, I have filed an additional affidavit with regard to item number 6, Lordship, which may be called for Lordship. Until the matter may be as time being Lordship.
Huh?
Till now, matter may be taken as time being Lordship.
As time being.
Till
Till the affidavit comes.
the affidavit comes, Lordship.
Ah,
Obliged, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 14. My senior, Mr. K. Goswami, has been appointed as amicus for this case. However, today morning he has developed some eye infection, and the doctor has prescribed him to take 1 day to monitor the situation.
1 day to monitor the situation.
Yes, sir.
Tomorrow.
Lordship, he'll tomorrow.
1 day will end today.
Today he'll just see if it develops any further. I.
Monday.
Monday.
All right, on the prayer made on behalf of Mr. K. Goswami, learned amicus curiae, who's having his eye treated. Come and list the matter on Monday.
Most of it.
Appeal against conviction for 20 years, Lordship. Under section 4.2 of the POCSO Act.
Heard, Mr.
D. Talukya.
D. Talukdar, learned counsel for the appellant, who submits that the judgment dated 28/6/23 passed by the Court of the Additional Sections Judge, Special Judge, POCSO, Dubri, in special case number 22/2021, by which the appellant has been convicted under section
Section 341, 342, 365 IPC, read with 4.2 of the POCSO Act.
has been convicted under section 341,
342, Lordship.
342
365 IPC.
and 365 IPC, read with section 4(2) of the POCSO Act 2012, should be set aside. Admit the appeal, call for the LCR, issue notice,
To respond number 2.
returnable in 4 weeks, in 5 weeks. Ms. El Jahan accepts notice on behalf of the state. Appellant shall thereafter take steps for service of notice upon the respondent number 2 by submitting Talabana. The said Talabana should be furnished to the learned PP, the additional PP, Ms. El Jahan, to enable her to transmit the same to the OC of the concerned police station, who shall serve the same to the respondent number 2.
He'll give a copy.
He'll give a copy.
Allowed.
The I is there, that will be taken after receive the LCR.
The report of service of notice should thereafter be made by the concerned OC. Leaves the matter after 5 weeks. Then in the IA, how much time at
4 weeks.
Ms. El Jahan, additional PP is granted 4 weeks time to file a written objection to the application under section 389 CRPC.
And Lordship will call for the LCR.
Already called.
Lordship.
Heard Mr. B.D. Kawar, learned senior counsel for the appellant, who submits that the judgment dated 8/6/2023 passed by the Court of the Additional Sessions Judge Dubri, in sessions case number 286/2015, by which the appellant has been convicted under section 302 IPC should be set aside. Admit the appeal, call for the LCR. Ms. S. Jahan accepts notice on behalf of the state, lists the matter after 4 weeks. Then in the IA, you write, Ms. S. Jahan is granted 4 weeks time to file written objection to the application under section KG9.
My lord, may I pay for any fixed date after 4 weeks? Keep it as per the convenience, madam. Then it's better.
Make it 5 weeks. best.
Yes,
5 weeks, otherwise 4 weeks too short of time.
Only your lordship.
Give a date. Any date.
Well, there is one item in supplementary hearing too. I'll do it next week. I'm having a severe throat infection, madam.
No, that is for tomorrow.
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 Ma'am,
Suppose-
you will make it.
You make a application today, written application, as
Yes.
per the notification
Yes.
made by the High
I've
Court.
already informed her, my lord, we'll make the application.
No, no, application is required, written application.
Yes, we'll do it during the course of the day.
This is, my lord.
Heard Mr. Jai Borbuya, learned counsel for the appellant, who submits that the impugned judgment dated 2023 passed by the court of the session judge Kamrup M. Guwahati in section case number 69/2018, by which the appellant has been convicted under section 302 IPC should be set aside. Ms. S. Jahan accept notice on behalf of the state. List the matter after 4 weeks. Then in the 389, 4 weeks time. Okay.
My lord, one thing, my lord, may be directed to prepare the paper book, my lord. after
Let the
LCR.
LCR first come.
After the LCR.
Let it come.
When this week, huh? Oh. For the counsel is not well. He had some throat problem. He treated himself outside Assam. Now he is here. He's quite serious, I'm told.
Okay,
Mr. Joshua Das.
okay,
The accused is otherwise inside for 7 years.
okay. Miss L. Jahan, additional PP submits that she has come to learn that the learned amicus curiae is having serious throat problem.
He can speak. His voice didn't come out.
Throat problem in as much as he cannot speak.
Paper book may be prepared. All sale is here.
As the LCR has arrived, registry to prepare the paper book and list the matter. After, no, not say, and, say, full stop, list the matter after 4 weeks. Yes,
Lordship, live streaming this call if they do the matter, hold on. Your Lordship, actually, the paper book, if it is
this paper book is prepared.
showing, my lord, but we have not received the paper.
We have not received. it.
You have not received paper book.
Yes, your lordship.
Cause list is showing, my lord. PB2.
Is there any extra paper book? Huh? Received. Received. R.A. Sultana.
R.A. Sultana for the informant maybe. R2.
Oh, R2. Okay, Miss, what is the name?
Yes, sir, no.
S. Sharma. Learned counsel for the appellant submits that she has not received a copy of the paper book.
Same here, Lordship, but our office.
No,
misplaces the paper.
madam, for you it has, you have received, your office, it says here.
Must
Paper
might be
book
F
has been
Sharma.
furnished upon Miss B. Buyan, additional public prosecutor for R1. On 25/7. It is signed by Benju Moni Daimari, our judicial assistant.
Yes, my lord. So our office.
That is your problem,
Yes,
madam.
I understand, my
We
lord.
we cannot clean up your house for you.
Lordship, but no copy has been provided to us.
No, it has been provided to your office.
It must be lying there.
We-
They don't
the
allow-
History
Most
cannot
of
run
the
after
cases-
individual lawyers. Your office is there for that purpose.
Lordship,
Your office is the post office. You cannot you cannot have a senior counsel be a post office. Your post office is your office.
Yes, the post office is, what to say,
You
my
clean
lord.
up you clean up your office.
Lordship, I'll get a Xerox from the code.
Whatever, you do whatever, but then you cannot take that ground, please. Don't take that ground. That is the fault of it. Either you are not looking after your office in a proper manner, or they're not obeying you. We don't know. We cannot be
No,
your
that's
guardian
not.
in that aspect. What have I said? Registry to furnish a copy of the paper book to Miss S. Sharma. Full stop. Next para. Though Miss B. Buyan additional PP has submitted that she has not received a copy of the paper book, comma, office note dated 25/7/23, which has been signed by Benjumoni Daimari, judicial assistant, states that paper book has been furnished upon Miss B. Buyan additional PP. Yeah. And it has been furnished upon you, not upon your office.
No.
Uh, list the matter. No, before that, say, office note also indicates that the counsel for the respondent number 2 has received copy of the paper. List this matter after 2 weeks.
Your Lordship, on 15th of September, if it is convenient, up to your Lordship.
Why? 15?
Then your Lordship, I will properly go through the paperwork and everything.
There is a matter on 15th September. For hearing. What about the IA?
Your Lordship, both may be disposed of together. Already it has long period of time has already elapsed.
Okay.
कोई बात
Ekelabate query. Both may be disposed of together, your Lordship.
Together. Why together? It can be disposed of today itself.
Your Lordship, yes, if your
Yes,
Lordship
We
is.
can dispose of
Yes,
today.
your Lordship,
all for the live stream.
They are missed. What do you mean missed? Okay, we'll wait for some time. They might come later.
The I is for declaration of the appellant as juvenile, I think, but
In item 10 only, Lordship. In item 10, Lordship, the plea was taken just time of Lordship committing the case. It was Lordship not fairly considered, Lordship, and accordingly.
Not fairly considered. What,
Lordship,
tell me
can
the-
we see the orders, Lordship?
let us see the appeal 32.
Lordship.
Yes,
Lordship. Paper book, Lordship, in page number 35.
where is the paper book? Where is that? Oh, no, I have it. Yes,
Lordship,
page number 35.
page number 35. Page number 35 is the Lordship deposition, Lordship, it was given by the administrators of the school, where this petitioner, Lordship, enrolled.
Yeah.
Lordship. Made it the evidence, Lordship.
normally borrow.
Normally borrow. Normally borrow.
But there is no date written in the admission register.
Lordship, Lordship,
That-
it was not the fault of this person, Lordship, because he took admission in the school, Lordship, in the year 1993.
And at that time, lordship knows that the condition of the drastic area lordship. Generally, lordship, the person are most of them are
And-
uneducated. So they lordship went to the school and they admitted in the school. So it was lordship not fault of this person lordship who was there. Lordship. The headmaster lordship ought to have been lordship,
According to you, when were you born?
uh,
According to you,
lordship. That school certificate was that.
Mr. Council, I'm asking you a very
Yes,
simple
Lord.
question. I'm not asking you school, sir. I'm according to you, when were you born?
Lordship, as per lordship, my certificate was on 16/11/1993.
When did the incident occur?
17/4, 2011. Since 17/4, yes.
Incident took place on 17/4/11. So.
So you were 17 years, according to you.
Yes, lordship. And lordship, it was, that plea was taken lordship immediately lordship when the incident took place, not lordship subsequently during trial or. So before lordship trial commenced lordship, he was taken lordship that he was a juvenile. And the learned lordship, court below, that is the judicial magistrate first class lordship. He just lordship called this person and recorded her statement, and on presumption lordship, he believed that he was not a minor, he was not a juvenile.
Huh?
Now he has filed an application under 391 for additional evidence. That may not be required. Lordship can
Right.
call for a report. If your lordship satisfies that he might be a juvenile.
No, it's not that. We have to make sure whether he's a juvenile or not.
Yes,
That
your
is the
lordship
issue.
has to be satisfied.
We have to be satisfied. And for that, there are only, we'll have to follow the juvenile JJ Act.
Mhm. And 313 statement, lordship can
Section-
see.
Section 7 lordship.
Not seven,
94,
94. Not sure, 94. You've got to go, there are 3 stages, I think.
Lordship.
1, 2, 3. And the last will be ossification, if there's no, if
Yes.
there's no document. Let them do it.
It's old book, but
In
Old
its
book.
313,
Now the new books are
Lordship,
coming.
lordship, in section 30, section 15 lordship. Sorry, lordship.
otherwise 313 shows that he was 20 years at the time of occurrence.
313.
30 years as reflected on to 2021. Rabiram. Rabiram is page 47. Thirty years, 21, so 11 is the occurrence, so 20 years. 313 doesn't show that he might be a juvenile, but then he's.
He has not stated.
Lordship, it was not probably lordship, it was not properly guided lordship, because it was lordship that since it's in 2011 lordship, the plea was taken. And so when it was rejected lordship, the learned, probably lordship, the learned council lordship did not guide him properly lordship. That is why lordship results happened. Otherwise, lordship, there is a good case lordship. Since he was minor lordship at the time of incident, and the plea was taken the very first day of the lordship appearing in the court. So there is no doubt at all lordship that he was a minor.
Because the school certificate, the
Yes.
witness writes that he was born
But
in
then, you see,
93.
no, but then the basis for writing that certificate, there's no basis.
There, yes, there is no basis. Whatever their
Yes.
parents is, this is what.
There's no
But
basis.
prima facie only, prima facie, if your lordship is satisfied that he might be a juvenile, then lordship will call for a report on the basis of 94 that inquiry will be done. Now, this will not cover. during the inquiry. This will not be
Report
the
will not-
basis during the
Which one?
inquiry. These school certificate or 313, those will not be the basis for inquiry. Basis will be-
That cannot be the big
Ah,
point.
94, section 94. So here, of course, if your lordship is satisfied, otherwise what she is saying is that I have written her his date of birth at 1611. There was no admission register and all. And he took admission in 99. At the time of admission, his age was recorded as 6 years. So that also shows us 93. His arrest memo. Lordship.
Lordship, if the started, yes.
The arrest memo can be seen. I'll see the LCR. Arrest memo, what
Arrest memo-
age is recorded?
Arrest memo, it will not affect, the exact date will not be there because
Not there.
school certificate was seized, Lordship, but subsequently it was not probably given to the person. But this is not with us. Might be in the LCR.
Yes. Let's see. Oh, no, school certificate, 9 years.
Yeah, what is that evidence? Evidence of PW? That headmistress?
At the Lordship. In paper book, it is
Yes.
page 35.
Arrest memo, it is shown 19 years.
Arrest memo is Lordship. They put that age without any.
This said 19 years. Robbie Ram. School certificate, I'm not getting.
Where is the school certificate? 161193?
Yes.
It was also seized, Lordship, but it was not returned.
Exhibit कौन है नहीं?
You-
It
you
was
should be
exhibited,
having-
Lordship.
Huh?
If it is exhibited, it might be Lordship in the LCR.
So
So exhibit
that's-
Lordship 3, exhibit 2, Lordship. Exhibit 2 is the
Exhibit two.
register.
Is the admission register? Admission register. is
Lordship,
nothing.
exhibit 1,
No, no, it's not exhibited. Where is the question?
exhibit 1, Lordship.
Huh?
And this is the statement of the headmistress, Lordship.
Yes, we have got it.
Lordship, sir.
We have what? We have got it in front of us.
Her statement is only there, but certificate Lordship might be in LCR, Lordship.
Yeah,
Lordship
exhibit.
may call for all those Lordship documents
No,
from the school, Lordship, then it will be clear. Because Lordship, the headmistress was, she was not the headmistress, Lordship, at the time of his getting admission. She subsequently Lordship promoted to headmistress. So she has Lordship stated as per the record of the school.
Meron, I don't exhibit file.
Exhibit for the record, and the exhibit police statement.
That's a
Okay.
judgment of.
Right. Heard, mister?
J. College.
J. Kalita, the counsel for the applicant. And Miss S. Jahan. The additional PP. This application has been filed under section 391 CRPC.
Exhibit file আছে না?
To take further evidence
No, no, no. I said judgment of the-
regarding the juvenility of the applicant in sessions case number 233/18 under section 302/34 IPC.
Just school register.
The applicant herein, that is Rabi Ram Das, has been convicted by judgment dated 16/11/2021, passed by the Sessions Judge Baksa, Mushalpur, in Sessions Case number 233/2018, under section 302 IPC. He was thereafter sentenced to undergo rigorous imprisonment for life with a fine of rupees 1,000. In default, rigorous imprisonment for 2 months. For the offence under section 302/34 IPC. Actually, earlier also you write 34, okay? 302/34. Good stuff. Next para. The applicant's counsel submits that the issue of the juvenility of the applicant had been raised by the applicant during trial. And this is, and for trial, full stop. He submits. Any application submitted separate?
Lordship,
Where?
it was mentioned, Lordship, that's petition number, Lordship.
Huh?
Petition number, page 9 of paper book, Lordship. And page 10 is a relevant, Lordship. Accordingly, the petition number 480 of 12 stand rejected. Page number 10, Lordship. Then first line of second paragraph. Accordingly, petition number 480.
As stated by mother of you. Hmm. In the records, can we see this 480 480/12?
480
This is the application.
application.
No, you should use 480/12.
Application.
What have I said? What have I said? What did I say the last sentence? In the trial. Why? Application number 480/2000, why is 2012? However, the application was dismissed by the learned trial court. As it was not satisfied with the plea taken by the applicant. While order dated 21/4/2012.
17.
So, next para. The learned counsel for the applicant submits that the evidence of the headmistress of Karwa, Anu Susita Jatiya Vidyalaya also shows that the headmistress bracket PW
Number is.
Certificate.
PW
PW number is not given.
Acha, the headmistress. What have I said? There's no PW, cut that. Headmistress. Shows that she had written the date of birth of the applicant as 16/11/1993 in the school certificate. In the school certificate, without any birth of date being mentioned in the admission register of the school.
That is the certificate. No, application was one.
Where is this where is this thing?
Application. Application. The application, I'm not finding it.
You're not finding it. Let us see this, is this, have you got the order sheet of the trial court? 21/4/2012, let's look at that.
21/4.
21/4/2012.
2012.
21/4/2012.
On 17 for it was pending.
21/4.
Application was pending 17.
Page 7 of the paper. Let me see.
21/4 is there.
Yes, yes. Okay. What have I said, the last sentence? In the school certificate of the applicant. In the applicant's school certificate. With the- Next paragraph. The learned counsel for the applicant thus prays that a juvenility test should be done to ascertain the age. No, the learned counsel for the applicant thus submits that determination of the age of the applicant at the time the incident and the age of the applicant should be done in terms of section 391 CRPC read with section 94 of the Juvenile Justice bracket Care and Protection of Children Act, 2015. The Juvenile Justice bracket Care and Protection of Children bracket close Act, 2015. Hereinafter referred to as the 2015 Act. Next. Ms. S. Jahan, the learned additional PP on the other hand submits that the age of the victim and age of the applicant in the arrest memo made on arrest memo
The date of his arrest was date to Nasal.
Seventeen for 11. Seventeen for 11.
arrest memo made on dash, shows
It is made on 18th.
18/4/2011.
11,
Shows that the applicant was 19 years of age.
19 years.
Also, in terms of the
That application.
Form.
has got-
wherein the applicants wherein the applicant was examined under section 313 CRPC. It shows that the applicant was 31 years, is it?
30
30
years
years.
on 21. during which-
31 years on 21,
No, 30 years,
30 years on
21. during
21.
September 21.
21, 9.
No, September.
Where is that 313 page?
Page 47. 23rd of September.
Was 30 years on 23/9/2021. Full stop. As such, even as per the examination of the applicant under section 313 CRPC, the applicant would have been
20 years. Less than 20 years. 19 years.
would have been 19 years,
11 months.
would have been above 19 years.
11 months, yes.
Huh? How much would have been?
19 years, 11 months, September.
Would have been above 19 years. Would have been 19 years, would have been 19 years. On the date of the occurrence of the incident, that is 17/4/2020, 17/4/2011. She just submits that there is no requirement. She just submits that the application should be rejected. Is that your case? Is that your case?
Not yet.
Because-
As a beneficial legislation, since it's a,
Right. Okay.
the
Miss-
application I've got in Assamese.
Okay. We have heard the learned causes for the parties. We have noticed that the applicant had taken the issue of, had raised the issue of juvenility with the learned trial court. By application number 480/2012. And accordingly, while order dated 17/4/2012, the headmaster of the school, headmaster of Kharwa Anushusita Jati Vidyalaya was asked to produce the admission register and to appear before the learned trial court on 21/4/2012. The headmistress of the said school appeared on 21/4/2012 and appeared before the said school on 21/4/2012 along with the admission register of the school. The headmistress was also examined. The headmistress, Mrs. Nomali Boro, Nomali, Boro, was also examined on 21/4/2012, wherein she stated that she had written the applicant's date of birth as 16/11/1993 on the basis of on being told of the same by the mother of the applicant. However, there was no date of birth mentioned in the admission register of the school. Relatable to the applicant. The learned trial court thereafter observed that there was nothing concrete to suggest that the appellant was a minor at the date of commission of the alleged offence. And that the school register created a doubt as to the authenticity of the entry made in relation to the applicant, as the entry in his name differed in handwriting, differed in the handwriting, with the entries of the other students. Full stop. Further, while the entry in the other pages of the admission register, school admission register, showed that the students were admitted at the age of 6 years and above, the entry of the applicant showed him to be 5 years. Full stop. The learned trial court thus held that there was a reasonable doubt created in the mind of the court as to the plea of juvenility taken by the applicant. The application of the applicant was accordingly rejected. By order dated 21/4/2012. Actually, this is not by the trial court. Well, not by the trial court, it's by the first class, by the judicial magistrate first class. No, sorry. This is not even during trial, they're prior to trial.
Prior to trial.
Prior to trial.
Now you have not, after this, you have not taken the plea anywhere.
Lordship, this is the problem, Lordship. Probably, Lordship, the engaged counsel, Lordship, did not guided him, that person, Lordship, properly. Because, Lordship, now I have, Lordship, gone to the record and I found that this is a very good case, Lordship. At least, Lordship, in a trial court,
Next para.
No findings in the judgment.
no finding in the judgment also, Lordship, under section 313 also, there is no such, Lordship,
No, but-
question.
No.
But then you have not taken, you have not
Lordship,
taken the
that is
plea
yes,
before the trial.
Lordship, that is a less on the part of this.
First off, we find that. Before that, you have continued. While the order dated 21/4/2012 passed by the Judicial Magistrate First Class Nalbari, comma. The case was also committed to the learned trial court for trial. No, for taking cognizance and trial. Full stop. Miss Parry. Subsequent to the above facts, comma. The learned, no, the applicant has not taken any plea during trial that he was a juvenile. The applicant has also not annexed any document before us
So now he is behind the bar, Lordship, and the case has been filed.
to show that he was a juvenile at the time of the incident. That was on 17/4/2011. The plea of juvenility having been rejected on 21/4/2012 by the Judicial Magistrate First Class, Nalbari. The applicant should have taken up the issue with the learned trial. However, the issue was never taken up by the applicant before the learned trial. He has only brought out the issues why the present applications which were submitted on 4/8/2023. On considering the fact that on considering the above facts, we are not inclined to.
Lordship, one chance may be given, Lordship, to establish his juvenility, Lordship. Otherwise, Lordship, it will be called prejudice, Lordship. Because of-
Sir, you had how many years before the learned trial court? You did not take up.
Lordship, because of not properly guided this person, Lordship, a juvenile, Lordship, should not be, Lordship, treated like a Lordship, this person. Lordship,
No,
one
you
chance
see,
may be-
you see, your the handwriting
Yes,
against
yes.
your name
Lordship.
is different
Lordship,
from the
if-
handwriting of the
Lordship,
other.
there is some suspicion, Lordship, then Lordship, the
that
magistrate
is what-
ought to have send him to the Lordship medical board for examination, for justification test and all, Lordship. That has not been done, Lordship. It is a great prejudice, Lordship. Lordship, one chance may be given, Lordship, to establish a juvenile.
Next. What have they said? Yeah. We're not inclined to allow the present application.
Or Lordship may call for a report also, Lordship, at your own, Lordship. Or Lordship, save the time, Lordship may call for a report. for
The application is accordingly dismissed. Not at this stage.
So, Lordship, that plea can be taken at any stage, Lordship, as per the law, Lordship.
Huh?
As per the law, Lordship, that plea can be taken at any stage, Lordship, not even any apex also that plea. Lordship, that's 23 judgment is there, Lordship, thus I have, this morning, Lordship, I have
At
gone to the
any
judgment.
stage, no quarrel. But then prima facie, it has to be shown that.
Prima facie, you have got to show that, see, we do not find the thing is that different handwriting.
Lordship, that's true, Lordship, assuming that all are different, Lordship, but Learned Court below, Lordship. what have
Only
been,
yours
Lordship,
was
presumed.
separate, yours are separate.
No, Lordship,
And yours didn't, and
I agree with you,
everyone
Lordship.
else admitted at 6 years,
everything is different.
yours is at 5 years.
Hi, that
And
may
a
be
different handwriting.
So, Lordship, the second stage is there, Lordship, procedure is there. If person, if documents is not satisfactory, Lordship, then the person may be sent to the Lordship medical examination for certification test for X-ray and all, Lordship. There is so much.
You see,
procedure.
you can raise the
That-
issue
yes,
at
that
any
is the
time.
mistake, Lordship, on the part of this person, Lordship. That-
You see, Mr. Counsel, you can raise the issue at any time,
Yes, Lordship.
but that does not mean that we have to allow your application. Anyway, we'll list the date anyway.
Not
They are not
sure, yes.
ready for hearing. That's what I know. Okay, right. As paper book has been prepared. In the mean case, list the matter for hearing after a week.
Yeah.
Or 2 weeks,
2 weeks.
after 2 weeks. In the IA, na, data, IA already order given. It's only
From the evidence on record,
The appellant ought not to have been convicted under 364A, rather 365. That is kidnapping for with the intent for wrongful confinement. Lordship, and only two witnesses evidence are relevant. May I straightaway take a lordship to those two witnesses?
Let us go first to the FIR.
FIR. Page 3, your lordship. May I read it?
Yes,
Sir, humble submission is that at about 3:30 PM on 17/7/2015, Thursday, the accused person named below took my son Sri Manas Muzumdar away by tricking him to go for a walk. Thereafter, we and the other members of our family have been searching for my son in several places, but we cannot locate his whereabouts. It is worth mentioning that some 3 or 4 other unknown persons were involved in the incident, along with the accused person named below. Hence, I request you to take necessary steps with regard to the incident and rescue my son, Sri Manas Mazumdar, from the classes of the accused person. Lordship, ultimately, investigation was carried on and charge sheet
just a
was,
minute, accused person, how many are there?
in the FIR, the
Yes,
name is
accused.
only the appellant. However, while filing the charge sheet, there were 9 accused persons.
So appellant is Anand.
Anand Devnath. And your lordship, ultimately, those other 8 were acquitted. Only the appellant, that is Anand Devnath, was convicted under 364. The charge sheet was filed and seizure was made of some phone, SIM cards and phone calls, but the prosecution was not able to establish how those SIM calls or phone numbers were established to any of the accused. And that's why those other accused got acquitted, your lordship. And the prosecution has examined 7 witnesses, prosecution witness, out of which PW1 is the father, who is the
Ah.
complainant, and PW7 is the IO. So your lordship, I will rely on these two because others are not that very relevant. Because one thing is established, your lordship, even from that the appellant has taken the minor child from the lawful custody of the parent,
How old?
3 years.
Why any relationship?
That has not come from the record.
So just take it, just like that.
Pathetic. So whether or not demand has been there for ransom or not, that is a thing that will be whether 364A or 365. And from the evidences I submitted, your lordship, that the prosecution has not been able to establish a demand for ransom has been made. So your lordship, may I read PW1?
Yes,
He is Manoj Mazumdar, the father of the child. The incident took place about 10 months ago. That is at page 9.
yes.
Yes. The incident took place about 10 months ago. On the day of the incident, Anand Devnath came to our house. Before the incident, he had repaired my rickshaw. Then it was evening. I was having mail inside my house. I called him too, but he did not come. I called my son Manas. Meanwhile, my wife told me that Anand had taken Manas away. Wife has not been examined also. On some earlier occasion also, Anand took my son Manas away for having a walk. I made phone calls to Anand, but he did not respond my phone call. I made 20 to 30 phone calls to him, but he did not respond to a single call. He switched off his phone. Then I lodged an SR with the PS. Exhibit 1 is SR, exhibit so and so. On the following day, someone, your lordship, he is not named. Someone made phone calls to me and demanded an amount of 50 lakh as ransom to set my son Manas free. Repeated calls were made to me demanding ransom. On being demanded, once I
Actually, no person will say that I am so and so, I have kidnapped your son. Why should they give their name?
yes, sir, I'll show that in
He'll
cross.
be the dumbest criminal otherwise.
Yes, but the cross,
Huh?
that for the demand has to be now the proof with that appellant had made the demand. Your lordship, from the cross examination himself, he admits, your lordship. The demanded amount and the money has also not been recovered from the appellant. That is important. And money has been, and this has not been stated before the police. The cross will say that. Anyway, your lordship, had made a demand of amount of 50 lakhs as ransom to set my son Manas free. Repeated phone calls were made to me demanding ransom. On being demanded, one side took an amount of rupees 3 lakhs along and left the amount amidst the trees along the road of Karigaon. After 2 days, some unknown person made phone calls to me, again unknown person, and demanded rupees 50,000 from me.
Has to be unknown, Mr. Kamal.
Yes.
It has to be unknown.
But if-
Otherwise, what is the point of kidnapping? Huh? If you tell the entire world who you are,
Yes.
the next day the entire state police force will come to your door.
there has to be a connection, Your Lordship. I'll show from the cross, Your Lordship.
It has to be unknown.
It has-
You, next time you tell me when you read, when you find out that someone has given his name, then you can act surprised, but not the other way around.
Your Lordship, it was not made from the appellant's phone number. No, it was appellant's voice was there. He has admitted it is not the appellant voice because this appellant is known to him. Now, those person, there has to be a connection established between, because other accused has been given.
Have you ever, I don't know, have you ever tried to disguise your voice with putting a handkerchief?
And the money has not been recovered from the appellant.
Most
And the
of-
other accused has been given, acquitted only on the basis because the phone calls, the SIM numbers were totally different. The prosecution could not establish a connection. Anyway, Lordship,
Yes.
because in the cross, this PW1 himself says, because since he is not the appellant, it is not the appellant voice, it is not the appellant phone number, and demanding way, and the mobile number also didn't belong to the appellant.
Okay.
Anyway, Lordship, after 2 days, there was another, so Your Lordship, this is important because this is the only basis where 364A has been this. After 2 days, some unknown person made phone calls to me and demanded rupees of 50,000 from me. In responding to the call, I told the person that I would hand over the money in person. As per instruction, I went to Bengal Bazaar, taking the money along. My uncle Madhav Majumdar and another person, Chinmoy De, these were not examined by the prosecution, Lordship. They are not prosecution witnesses. Accompanied me. When Anand Devnath brought my son to Bengal Bazaar, Madhav Majumdar and Chinmoy De caught him and brought him to our house. So the trial court basis of conclusion that he ought to be convicted under 364A is that there was a demand for ransom and asking the child to be delivered at a particular place. And when going to do that act, they apprehend the appellant. The IOs
With the child.
with the child. That is the only basis of connecting the demand for money, because the initial money was deposited somewhere, deposited by some person who is not even examined, Your Lordship. And the phone calls also cannot be traced to the appellant. This is the only basis. However, the IO statement in his evidence, the story is totally different. This is a contradiction. So there is no conclusion of recovering
How
the
long was the child missing?
13 days.
13 days. I just read another 4-5 lines of the. Got him, brought him to a house. We did not give that information to police because had we failed to give the money that day, Manas would have been killed. When Ananta was brought to a house, a lot of people gathered there and they attempted to assault Anant. Whereupon I made call to additional SP, day after police came. So according to him, the police came to the PWD's one home after the Anant and child was brought to their home. And I will show from the IOS evidence that's his statement, then this story is totally different. How the child was recovered. So this connection of that the child was recovered pursuant to a phone call at a particular place when they had gone to collect, give the money, that is not proof. So the 364B would not be applicable. That is the only thing. Otherwise, this case is, this one thing is certain, that prosecution had been able to establish that he had taken away the lawful custody of the child from the parent. Anyway, from cross, Your Lordship, the last 5th line from bottom. It was not Anand voice, Your Lordship got it?
There are seeing Ananta taking Manash away.
Okay. Seeing Ananta taking Manas away, when I asked him to where he was taking Manas, he replied that he would purchase chocolate for Manas. I did not state before police that I have given ransom.
So what is this? What is this seeing Ananta taking Manash away? What is the?
Your Lordship, actually, he had taken the child away on the pretext of giving him chocolate because the appellant is known to him. That's what he says in his examination chief, that he had been informed by wife that the appellant had taken the child away for a walk. And in his cross-examination, he has said that when he had asked the appellant, he has said that he has taken away the child on the, for giving some chocolate. So this person remains unrebutted. I did not state before police that I had given ransom of rupees 3 lakhs to the kidnappers because the police had asked me to not to pay the ransom. It is not a fact that I did not state before police that my wife had taken Ananth taking Manas away. It is not a fact that I had stated before police that Ananta had kidnapped Manas when I was not at home. It is not a fact that I did not state before police that I had made 20-30 phone calls to Anant. Your Lordship, from this here, it is important. It was not Ananta's voice which I heard demanding ransom of rupees 3 lakhs. It was also not Ananta's voice which I heard demanding subsequent rupees of 50,000. The mobile number did not belong to Anand. It is not a fact that Manas was not rescued from the classes of Ananta. It is not a fact that Ananta has not kidnapped Manas. So it is the, I'm relying on this part to show that it was not the appellant that has demanded the money. And if at all someone had demanded the money, then the prosecution has failed to arrest him and connect him with the appellant. It is a fact the appellant, whether he had demanded money or not, that has to be proved also. And
No,
Your Lordship,
But what about the fact that as per instructions,
yes, Your Lordship.
he had gone to the bazaar
Yes.
with the money,
Yes,
and do you think it was coincidence that Ananta had come with his son?
if that is proof, yes, I Lordship, I hold on. Your Lordship, page 18, the evidence of PW7, the IO. May I read?
Yes.
Yes, around 6:30 PM on 17/7/2015, one Manoj Muzumdar informed the Kukuraja PS that one Anand Devnath had taken his son along for having a walk, and since then both of them had gone missing. On receipt of the information, the OC of the PS made an entry on the GD and entrusted me with the charge of the investigation into the matter. I questioned the informant and sent WT message to all the police stations. I also questioned the other witnesses. From here, Your Lordship, is important. On 18/7/2015, that is the date of the recovery of the child. From here, a written SR was lodged in connection with the incident. I engaged secret informers on several places. I arrested some accused person on 30/7/2015. Actually, this is the date when the child was recovered. Accused Anand Devnath was apprehended while he was crossing a road along with the victim. So it is the IO who has apprehended the victim, appellant along with the child. It is not the PW1 story statement is that it is they who had apprehended the appellant and brought them to a house and thereafter informed the police. In connection with one auto rickshaw was seized. Exhibit 3 is a seizure list and exhibit 3(1) is my signature. The rider of the auto rickshaw was arrested. I submitted a charge sheet against the accused. Exhibit 4 is a charge sheet and exhibit 1 is my. These are not necessary, Your Lordship. May then come to the cross-examination of the last para. Page 19. Witness Kamal Handik did not state before me that money as ransom had been demanded for setting Manas free. That rupees 2 lakhs had been paid as ransom and that after apprehending Anand, they had written up. It is not a fact that I did not apprehend Anand while Manas was along with him. So as per the IO, it is he who has apprehended. If this is to be accepted, then the entire statement of PW1 that on receiving information or on a demand over phone call, he had gone to the bazaar and apprehended appellant goes along. So there is a doubt as to how the child was recovered from the appellant, from which place the child was recovered. So accordingly, the statement of that there was a demand and thereafter they went, that also cannot be taken. Because there is doubt on the PW1 statement because there is contradiction between PW1 as well as the IO. So the demand story cannot be taken as or has not been proved beyond reasonable. If that be so, only thing that has been proved by the prosecution is that the child was taken away from the lawful custody by the appellant. And then he ought to have been convicted under 365, where the punishment is 7 years, not for life. And Your Lordship, he was arrested soon after the lodging of the FIR. So it's almost 8 years he's under imprisonment, subject to correction, because he did not get any bail after that. So he has served more if your lordship is convinced to convert it into 365. And your lordship, this came up before this honorable court. If the charge sheet is under 364A, whether conviction could be under 365. This question came up before this honorable court, where the honorable court said yes, relying on 221, 1 and 2 of the CR.
That can be done.
Ah.
If it's a lesser sentence.
Yes. Now, your lordship, the other points to be thinking is that money has not been recovered from the appellant. The other it has been accused. Who made the phone calls?
No,
And
money, non-recovery of money can be for various reasons.
On the
Can be
sole, on the sole basis, yes, that cannot be done. On the facts and circumstances of the entirety of the case here, money is not recovered. Purely one statement cannot be taken as to be wholly true. Because the entire story of purely one of recovering on the basis of demand being made. And also, this other two person has not been examined. PW one was has supposedly gone with two other persons. Those has also not been examined by prosecution. And where SIM calls, the history of the phone calls being made, SIM calls, nothing has been done. Only things they have been seized. That is why the other it has been acquitted. That is my humble submission. You should get the benefit of 365.
Before going to the evidence on record, I would like to refer section 364A of IPC. Roshi, may I read, my lord?
Yes.
Roshi, may I read? Whoever kidnaps or abducts any person or keeps a person in detention after such kidnapping or abduction and threatens to cause death or hurt to such person, or by his conduct give rise to a reasonable apprehension that such person may be put to death or hurt, or causes hurt or death to such person in order to compel the government or any foreign state or international intergovernmental organization or any other person to do or abstain from doing any act or to pay a ransom shall be punishable with death or imprisonment for life and shall also liable to be fined. So ingredients under section kidnapping for ransom under section 364A kidnaps or abducts any person or keeps a person in detention after such kidnapping or abduction and threatens to cause death or hurt to such person, or by his conduct give rise to a reasonable apprehension that such person may be put to death or hurt. Lordship, these ingredients are to be fulfilled to convict a person under 364A, your lordship. Now, I want to take your lordship to the evidence of PW1, my lord. The father of the victim. At page 9.
Yes.
PW1, the incident took place about 10 months ago. On the day of incident, Ananta Devnath came to our house before he had repaired my rickshaw. Then it was evening. I was having meal inside my house. I called him too, but he did not come. I called my son Manas. Meanwhile, my wife told me that Ananta had taken Manas away on some earlier occasion also. Ananta took my son Manas away for having a walk. I made phone calls to Ananta, but he did not respond to my phone call. I made 20-30 phone calls to him, but he did not respond to a single call. He switched off his phone. Then I lodged an Azahar. On the following day, someone made phone call to me and demanded an amount of rupees 50 lakhs as ransom to set my son Manas free. Repeated phone calls were made to me demanding ransom. On being demanded, once I took an amount of rupees 3 lakhs along and left the amount amidst the trees along the road of Karigaon. After 2 days, some unknown person made phone call to me and demanded rupees 50,000 from me. Responding to the call, I told the person that I would hand over the money in person. As per the instruction, I went to Bengal Bazaar, taking the money along. My uncle Madhav Mojumdar and another person, Chinmoy De, accompanied me. When Ananta Devnath brought my son to Bangla Bazaar, Madhav Majumdar and Chinmoy De caught him and brought him to our house. We did not give that information to police because had we failed to give the money that day, Manas would have been killed. When Ananta was brought to our house, a lot of people gathered there and they attempted to assault Ananta, whereupon I made phone call to additional SP. Thereafter, police came and took Ananta away. Then in cross minus, seeing Ananta taking Manas away, when I asked him as to where he was taking Manas, he replied that he would purchase chocolate for Manas. I did not state before police that I had given ransom of rupees 3 lakhs to the kidnapper because the police had asked me not to pay the ransom. It is not a fact that I did not state before police that my wife had seen Ananta taking Manas away. It is not a fact that I stated before police that Ananta had kidnapped Manas when I was not at home. It is not a fact that I did not state before police that I had made 20-30 phone calls to Ananta. It was not Ananta's voice which I heard demanding ransom of rupees 3 lakhs. It is also not Ananta's voice which I heard demanding subsequent ransom of rupees 50,000. The mobile number did not belong to Ananta. It is not a fact that Manas was not rescued from the clutches of Ananta. It is not a fact that Ananta had not kidnapped Manas. So, Lordship, as per the evidence of PW1, reasonable apprehension appeared in the mind of PW1 that he might be killed, my lord.
That what was the basis for that apprehension?
Because it was already 13 days have gone by, my lord. So, your lordship, it was in the custody of the accused person. He was in the custody of the accused person. And your lordship, as per the evidence of PW4, lordship, he also saw at 3 p.m. saw Manas in the lap of accused person, my lord.
But where is the, what gave rise to that apprehension?
As
Where
the
is-
minor son was taken away by no information, he did not pick up the phone calls 20-30 times the phone was called. And your lordship, that environment that the reasonable apprehension has arisen in the mind of the lordship father of the victim.
Madam,
That has not been confronted, your
no,
lordship.
no, that's not the
My lord.
issue. The issue is that the section says that.
My
states
lord.
that, and threatens to cause death or hurt to the person. Or by his conduct gives rise to reasonable
to the
apprehension.
conduct,
Now,
my
what
lord.
is the conduct?
Conduct of taking the child away
Taking a
from
child
the
away.
custody for 13 days, no information.
Okay, so according to you, if a kidnapping is done for, say, 5 minutes, that will not cause apprehension of death.
Lordship,
What
what
would be the
lordship,
parameter? What would be the
Lordship,
border?
what I have learned from my seniors, my lord, the first day of kidnapping is very much crucial.
Mm.
If the first day it is not killed, your lordship, and nothing, if it is nothing is done, it is relating to terrorist, my lord, then there is a likelihood that he might be. But in this case, 13 days, it's not, he was not kidnapped by any terrorist, my lord. It was a person who is known to him. But still then, your lordship, that person did not pick up the call, your lordship. And several phone calls have been, they have received several phone calls from his number demanding ransom. If your lordship considers the evidence of the IO, my lord. Lordship, because phone calls have been made from the phone of Ananta. As per the evidence of the IO,
You see, madam, you see, you cannot put all cases
my lord.
into one jacket or
Lordship, I
one
understand,
straight jacket.
My lord.
It has to, you have got to consider different situations.
my lord.
Kidnapping by a terrorist
Yes,
or kidnapping by a relative or
Yes.
kidnapping by a person known to you or kidnapping by an unknown person who is not a terrorist. They are all different.
yes, your
So,
lordship. But
facts.
13 days,
So
no information to the parents, my lord,
I do not know.
from the lawful custody.
There
he
was
taken away.
information. There was information because you went and deposited 3 lakhs also at one time. What do you mean for 13 days there was no information? There was information. That's why you went and deposited 3 lakhs.
But the demand is there, my
Then
lord.
again there was a demand.
No,
And again, you
33
say
lakhs,
150.
even if it is 1 lakh, there was
So,
a demand, my lord,
so there is, it's not a question of there being no information for 13 days.
my lord.
So you see,
But still then, after 3 days, this person, the PW,
okay, just tell us,
my lord. Now I
according
want to
to,
take your lordship to the evidence of IO, my lord.
according to PW1,
My lord,
PW1 says that he caught with Madame Mazumdar and Chinmoy Day, they caught this Anand and they took him to their house. And thereafter, the additional SP was called. And thereafter, police came and took Anand out. But that is not the evidence of the IO.
IO.
So who is telling the truth?
Lordship, even if your lordship takes up the evidence and rejects the evidence, the other one, but still that admission, my lord, that the victim has been taken away by the accused person, lordship, and he was apprehended, whoever may be the police or first by the villagers or whoever acquaintance, and thereafter by the police. But admitted position, the victim has been taken away by the accused person, my lord. It's not the case somebody else has been
See,
taken away,
that
not their
is
case,
that is not their case. Their case is that yes,
Lordship.
maybe taken away.
my lord.
But the fact of their evidence not being supported by the IO
My lord,
with regard to who apprehended the appellant also raises a suspicion and a doubt as to whether there was any money paid also. And as to whether your apprehension is also genuine. Now everything is, you see, you cannot say part of that evidence of PW1 is believable and part is not believable because IO has said this. It has to be in full, wholesome. So now if we say that, okay, we do not believe PW1, we do not believe IO also, but the fact remains that he was kidnapped by the appellant. Okay, he was kidnapped by the appellant. Now, who has apprehended the appellant, we don't know. Because we have to either believe one PW1 or we have got to believe PW7, either one. The apprehension part.
there might be two
arresting
parts,
part.
my lord.
Yeah,
There might be two parts.
they might be, but then that is not here.
No,
We
first,
cannot
as
speculate.
far if your lordship considers evidence of PW1,
Mm.
Madham Majumdar and Chinmoy caught him and brought him to our house.
Yes,
We did not give that information to police because had we failed to give the money that day, Manas would have been killed.
correct.
Lordship, then
No, I'm not on that.
that subsequent
You
event,
see, according to PW1, they caught the appellant
yes,
without the police being present.
yes,
And thereafter the police came and took him away.
yes,
Now, PW7,
yes,
on the other hand, states that he apprehended the appellant with the child.
yes.
So, do you mean to say that it is both the stories go well together? Do they gel? They're contradicting each other.
Is there, but I meant to say, your lordship, first he might have been apprehended by
Might
these
have-
two persons.
Might have been okay then. Might have been.
Evidence is same, my lord. I was not the.
No, that is why, no,
yes.
but the two
But your
evidences
lordship, it
contradict each
doesn't
other.
raise any doubt regarding the apprehension part. And if your lordship, lordship brush aside the evidence that who has apprehended, the other person still remain, the kidnapping part and the phone calls made. Phone call made for ransom, my lord. From
is-
the phone, yes, from the evidence of the IO itself, my lord.
How do we know he has made 50,000 phone calls or 10 phone calls or one phone call? Why do we presume?
There's no CDR.
Why do we presume?
Lordship, as lordship, because your lordship, we don't
If
have
you
any-
want-
accept the evidence on record, my
If you
lord.
want to be, you see, when the prosecution has to prove their case beyond all reasonable doubt. Can we accept everything that they say without proof?
That is
When
there.
it-
Lordship, but the IO says, as Modern Goyari Khaibo so and so demanded money as ransom from the informant by making phone calls to him through Ananta's mobile phone. They too were arrested. Later on, they were released, they were acquitted. But the phone call was made from the phone of Ananta, my lord, the main appellant here. So it is remain unshaken. As per the evidence of IO, he is the official
You see,
witness.
you see, kidnapping is usually done for ransom.
Yes.
That is, unless there is some enmity. Otherwise, but then the fact of an apprehension that he may be killed. That from where do you get that? How do you say that from your seniors? This is the experience. Now that we
No,
cannot,
no, we
I
have to
cannot write,
submit.
I
Lordship,
cannot
from
write
the
that.
evidence on records,
No, so
which was submitted, which was, Lordship, as per the evidence of PW1, Lordship, he has given evidence that it has, if we inform the police, he might be killed. So, your Lordship, reasonable apprehension has arisen in his mind, my lord, that the child may be killed by this kidnapper. And it was just demolished by way of cross-examination. And there is no plea in 313 statement. Nothing has been given, nothing has been.
313,
Even in
that question
313.
was not put to. That is another thing. 313, very limited question was. And regarding the lordship, the phone. First of PW1 himself says these are not his voice, not his phone number, not his phone call. And the IO, the seizure list was made on 18/7, date of the Azahar. And the accused was apprehended on 38. So the phone seized was not of the appellant. It was of other arrested person who were later on acquitted. If you say lordship sees a seizure list, it's 18/7,
page,
page 43 and 44. And the lordship has rightly pointed out, lordship, that the entire story of PW1, the demand being made, that's why they went to deposit the money and and recover the child. That entire story goes because of the IO's contradictory statement. That entire statement cannot be taken in part, that they had recovered, and more importantly, they had recovered the child, then brought to their house, then they informed the SP. The police was nowhere in the scene. Police had, and as per the IO, police had apprehended from the bazaar. So that part has to be taken out totally. Only that demand part has to be also taken out of it. So only thing that has been proved by the prosecution is that the appellant has taken the child from the lawful custody of the parent, and the appellant is known to the father of the father and mother of the child. So for what purpose, that is not found, but definitely not for demand for ransom. And so this.
what is this seizure list you were saying?
Seizure is 43 and 44.
Yes, what about it?
These were seized on 18/7.
So,
So this cannot be the phone of the appellant. These are somebody else's phone. Because the appellant was arrested on the date of the recovery of the when the child was also recovered, 38.
so these phones are what? Whose phone?
That is not being proved whose phone.
So this, no, so what is the relevance of these
There's
phones?
nothing, no relevance, because now this IO's statement that the phone calls were made through Ananta's mobile phone is without any basis.
From his phone call, other persons call the victim's father
whereas the
demanding ransom, my lord. So, Lord, other persons would have been apprehended
Other
earlier than the
persons,
Ananta.
other persons asked for ransom from Ananta's phone.
Yes, my lord, that is the
Where is the
evidence of
CDR record? Where is the
CDR.
They could not
Say-
prove, that's why the others were acquitted, Your Lordship.
CDR
There's
is not there.
nothing connection between the appellant and the other accused, other phone, the CDRs, nothing been. The link has not been established.
Where is the certificate under 65B?
These are procedural irregularities, your lordship. It happens in every case, then all the accused get acquitted, your lordship.
What to
With
do?
your lordship,
What to do? Supreme Court says that 65B is required. Can I say that it's not required?
no, your
that we
lordship,
should-
if your lordship takes the part, other evidence still remain. Kidnapping part, demand of ransom, apprehension in the mind of the PW1.
Apprehension has to be based on something. He should have at least said that he was threatened that he would be killed. Supposing he said that he was apprehensive that he would be sent to America by ship to be made a slave. Can we believe that? There has to be some basis for coming to an apprehension. There is no basis. We'll take it up at 2. So basically that's okay. Yeah. Anything else to be added? Okay.
Reasonable apprehension that third person will put you there. So the reasonable apprehension arises in the mind of the PW1 that the victim will be killed by a accused person and then after lordship. And your lordship, the demand has been made by the PW1.
Okay, yes.
That of demand has been made by the PW1 once by giving 3 lakhs of rupees earlier. It came on evidence of record. Lordship, page 9.
Huh.
Once of the part payment has been made to the person. Page 9.
There.
6 9. On being demanded, once I took an amount of rupees 3 lakhs along and left the amount emitted trees along the road of Karinga. After 2 days, some unknown person made phone call to me and demanded rupees 50,000. So there was demand, even PW5 states the lordship.
All these things you did not tell the police. Though you were apprehensive that you might be killed.
Lordship.
But then the police had arrested.
The arrest still remains, but apprehension is lordship may not be very clear. But your lordship kidnapping part.
Kidnapping part could be there. I do not know. We don't. They should be ransoming. They should naturally, it's a corollary in a way. But then there's nothing really established. Anyway, could be. There's nothing to doubt it. There's nothing to doubt it. Only thing is that with regard to the apprehension, because it has to be by some action or the conduct that, the apprehension should arise that might be killed. But out here, you have not stated what is the conduct. So, that apprehension, calling for ransom, demand does not give. No, demand, I don't really think so. Anyway,
Lordship, somebody is taken away without any information, no information for 13 days, my lord, except the phone call. Naturally, my lord, that apprehension will come in the mind of the person.
no, without any phone calls, no. PW1 says repeated phone calls were made to me.
Yes.
Demanding
regarding
that,
master
yeah.
dowry.
So phone calls were there. Phone calls were there. It is when there are no phone calls that you should be worried, but phone calls were there.
Phone call-
You have not stated that that I was threatened that if I did not make payment, I'll be killed.
So reasonable apprehension in the mind, my lord. So apprehension, yes, since they are stated before the court, my lord. In a substantive.
Anything else? Anything else besides that? Yes, yes.
Minus. Regarding N or that is there in the definition, my lord, I think.
And or
and or, that is there in the.
With
definition
regard to
itself.
what, in what context do you want us to read it?
Regarding the apprehension part, the whether. How much 21 is
2021,
21.
9 SEC,
Nine.
15 para,
There are 12, 13, 14, 15, 20, all the parents, all, everywhere it has been discussed, you know. 26, 27 is being given.
okay, right.
Actually, may I.
Heard Mr. R. Sarma, learned amicus curiae, and Ms. B. Buyan, additional PP. The present appeal has been preferred against the judgment dated 14/9/2017, passed by the Sessions Judge Dibrugarh in Sessions Case number 33 bracket J-T bracket close slash 2017, by which the appellant has been convicted under section 364A IPC and sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, in default, simple imprisonment for 3 months. The brief facts of the case is that an FIR dated 18/7/2015 was submitted by PW1, who is the father of the kidnapped victim, with the officer in charge, Kokrajhar Police Station, stating that at about 3:30 PM on 17/7/2015, the appellant had taken away his son by making him go for a walk with him. Despite searching for his whereabouts, they could not trace his son. They accordingly prayed that necessary action should be taken to recover his son. Pursuant to the FIR, Kokrajhar PS case number 633/2015 under section 365 IPC was registered. Next paragraph. During investigation of the case, eight persons were initially arrested. Thereafter, the appellant was arrested along with the child on (30/07/2015). The investigating officer bracket PW7 thereafter submitted his charge sheet on having found a prima facie case under section 120 bracket capital B slash 365 slash 364 bracket capital A slash 366, 344 slash 369 IPC against the appellant and the other 8 persons arrested earlier. Pustam. Charge was framed against all the arrested persons under those 4 sections. To which they charge was framed against, but and which provision? Charge was framed against the
364A
this is under section 364 bracket A
and 34.
and 34 IPC against all the accused persons, including the appellant, comma, to which they pleaded not guilty and claimed to be tried. Full stop. Next. The learned trial court thereafter examined 7 prosecution witnesses. And after examination of all the accused persons under section 313 CRPC, comma, the learned trial court came to a finding that the appellant was guilty of having committed the offense under section 364 capital A IPC. However, the learned trial court acquitted all the other 8 co-accused persons on coming to a finding that the prosecution had not been able to prove the guilt of the other co-accused persons. In the case. Dio, okay. 7 prosecution witnesses and 1 EO means
Proclamation machine.
oh, okay. So if that necessary, doesn't, that's nothing. Oh, proclamation, then. Okay, next, huh? The appellant's counsel submits that that out of the 7 prosecution witnesses, only the evidence of PW1 and PW7 are relevant to decide the facts of this case, to decide the facts of the case. He submits that as there is nothing to prove that that demand for ransom had been made, and as there was nothing to show, and as there was no basis to show that there was that the apprehension on the part of the victim's father was that his son would be put to death or would have been hurt, comma, the provisions of section 364A IPC would not be attracted. And at best, the appellant could have been convicted under section 365 IPC. Next paragraph. He also submits that The next para, the appellant's counsel submits that the evidence of PW1 shows that the appellant and appellant had been caught by his uncle Madhab Mazumdar and another person named Chinmoy Day. When he had brought his victim son to the Bengal Bazaar, where he was to hand over rupees 50,000. The appellant was thereafter taken to the house of PW1 and a call was made to the additional SP. Thereafter, the police came to the house of the PW1 and took
The citation has cited it goes with the figure. The and part of this.
could be and good for him.
It's okay, but I thought, so.
Correct. He might thank you, might, I don't know. What will be the final result, but he might thank you in the canteen or something. Some laddus or something like that. Yes, what? And took away the appellant. Full stop. On the other hand, the evidence of PW7 bracket investigating officer is to the effect that he had apprehended the appellant along with the victim boy when the appellant was crossing a road along with the victim on 30/7/2015. Full stop. Next para. The appellant's counsel submits that the contradiction that the contradictory positions taken by PW1 and PW7 with regard to apprehending the appellant casts a doubt on the testimony of PW1 with regard to no, not with regard to testimony of PW1. First up, accordingly, there being no proof with regard to any money being handed over, with regard to any ransom being made by the appellant to PW1. What have I said? By any ransom being asked for by the appellant to the respondent number 1. And as there is no evidence to the effect that calls were made by the appellant to PW1, section 364A IPC could not be attracted. Full stop. Similarly, now further, there is no similar further. Though PW1 had stated that he was apprehensive, has stated that if he failed to give the money, has stated that he did not give information to the police regarding the money that had been paid and was also to be paid. No. This is he also submits that PW1 in his evidence had stated that rupees 3 lakhs had been left amongst trees along the road of Karigaon and that another 50,000 was to be paid to the appellant. Full stop. He submits that PW1 in his evidence further states that the said information was not given to the police because they were afraid, because he was afraid that his son would be killed if the said information was relayed to the police. Full stop. The appellant's counsel submits that there is nothing in the above evidence of PW1 to show that there was any apprehension, that there was any reason given by the appellant or any other person that the victim boy would have been killed if money was not paid. Accordingly, section 364A IPC would not have been attracted to the facts of this case. Anything else?
And the cross-examination that his voice is not his number, is not his
Full
voice.
stop. Next panel. He also submits that in the cross-examination of PW1, PW1 states that he did not state before the police that he had made 20/30/40 calls, 20/30 calls to the appellant. He further stated that he did not hear the appellant's voice while the ransom demand had been made. Ransom demands had been made. Further, the mobile number did not belong to the appellant. Full stop. That's all. Anything else?
Yes, and no, his phone was never seized to prove this fact.
Full stop. He further submits that the phone of the mobile phone of the appellant was not seized by the police to prove that the appellant's phone had been used for making any ransom calls to PW. That's all. Full stop. Next, Ms. B. Boyan, the learned additional PP, on the other hand, submits that as the appellant, as the SPW1 had earlier deposited 3 lakhs amongst trees on the Karigaon Road and had also taken along rupees 50,000 to Bengal Bazaar, from where his uncle and another person, Chinmoy Day, had apprehended the appellant with his son, clearly goes to show that ransom calls had been made by the appellant. Full stop. She further submits that as the abducted boy had been missing for 13 days, there was a reasonable apprehension on the part of the applicant, on the part of PW1, that that his son would have been killed if the ransom amount was not paid. Anything else? First up, the PW1 accordingly did not inform the police, as he was afraid that his son would have been killed if the said information was given to the police. No, earlier part also not informed.
Regarding the payment made. Regarding the payment part, it is not informed to this. Because reasonable apprehension that the Admittedly, there are two parts. The first is that I can report this like.
But that part also is silent. How can we assume something when it's silent?
Lordship, we did not give that information to the because had we failed to give the money that way, Manas would have been killed. So already that part has been given. My submission. Because two parts.
No, this is not your submission.
Two parts, my 3 lakhs already given. And later on, it was given that within 3 lakhs to police, to that, it was not informed to the police.
Where is the IO's evidence to that effect? Let's see. How can you say something beyond the evidence? I wonder.
I think the evidence of people who are.
No, when you're citing the evidence, you have to cite it as it is. You cannot add something which is not there.
Lordship, because earlier he said 3 lakhs given and then there are.
Okay, you say one thing. And the learned PP, additional PP submits that the evidence of PW1 implies. That's what you're trying to say, implies. Implies that the dropping of 3 lakhs as ransom amongst the trees in the Karigaon Road is clear. No, implies that implies that the implies that PW1 had dropped off rupees 3 lakh along the Karigaon Road. Only implies. That's what you cannot say something which has not there. How can you say that?
Yes, my lord, we did not say
Huh?
and base that.
Yes, say what?
We did not give that information to police. Because had we failed to give the money that day, Manas would have been killed.
Yes. So, with regard to what? With regard to which transaction?
That giving 3 lakhs.
No, how, where? Subsequent demand, there is
That is
subsequent,
50.
yes, there's 50,000, that's it. It's nothing to do with the 3 lakhs. You cannot add words that are not there. Anyway. You cut that entire thing. Cut that entire thing. Next. So where are we? Mhm. He submits that as the fact of the kidnapping of the victim is not in doubt. There is no infirmity with the impugned judgment passed by the learned trial court. Full stop. Accordingly, the same should be upheld. Full stop. We have heard the learned counsels for the parties. Full stop. The evidence of PW1, who is the father of the abducted boy, is to the effect that when he went home in the evening, when he was having his meal inside his house, he called for his son, Manash. However, his wife told him that the appellant had taken Manash away. Further, no, first stop. As the appellant used to take his son for a walk on earlier occasions, he made a call to the appellant. First stop. However, the appellant did not respond to his phone call. He thereafter made 20-30 phone calls to the appellant, but there was no response as his phone was switched off. Thereafter, he lodged the FIR. So, He lodged his FIR. First off, on the following day, some person made a call to him and demanded rupees 50 lakhs as ransom to set his son free. First off, repeated calls were then made to him demanding ransom. First off, PW1 thereafter took an amount of rupees 3 lakhs. Now, I do not know from 50 lakhs how suddenly 3 lakhs. No, it's okay. But they come down so fast from 50 lakhs to 30 lakhs, 3 lakhs, huh? But then you have not stated anywhere, PW1 has not stated that 3 lakhs was demanded. He says 50 lakhs was demanded, but he gave 3 lakhs.
Chinmay has given 3 lakhs. Rashid, but Chinmay has not been.
Acha, one more thing you got right. The appellant's counsel submits that the uncle so and so, uncle Madhab Majumdar and the other person Chinmoy Day have not been examined as prosecution witnesses. Okay, then however, 3 lakhs and left the said amount amidst the trees along the Karigaon Road. Fusa. After 2 days, an unknown person made another call to him and demanded rupees 50,000. Fusa. Responding to the call, PW1 went to Bengal Bazaar, taking with the money as per instructions received. Fusa. When the appellant brought his son to Bengal Bazaar, his uncle Madhab Mazumdar and one Chinmoy Day, who were accompanying him, caught hold of the appellant. So he further states that he did not give the information, he did not give any information, he did not give the information to the police because if he had failed to give money on that day, his son would have been killed. The appellant was thereafter brought to the house of PW1, wherein the people who had gathered there attempted to assault the appellant. On PW1 having made a phone call to the additional SP, the police came and took away the appellant. Next paragraph. In his cross-examination, PW1 states that on seeing the appellant taking away his son, he asked him where he was taking away his son. The appellant then replied that he would purchase chocolate for the abducted boy. So, earlier in his evidence examination chief, he said that while having a meal, he asked his wife, and then his wife told him. But here, he himself saw the appellant taking away his son.
Second part, please, but for ransom, that is, bid has to pay for it. That is not. We with the submission. Please, please, but please.
Must be a, and usually all this kidnapping and all done chupke out here, full broad light, broad daylight. There's something not connecting. There is something not correct here. Anyway. PW1 also stated in his cross-examination that he did not state before the police that he had given rupees 3 lakhs to the kidnappers because the police had asked him not to pay ransom. So here also he has not. Full stop. He also denies the suggestion that he had not stated before the police that the appellant had kidnapped his son while he was not at home. He also states that he did not state before the police that he had made 20, no, that, forget this. He also states that, he also states in his cross-examination that he had not heard the appellant's voice when the demand for ransom had been made. The evidence of PW 2 and 3 is that they had heard that the victim, that the son of PW1 had been kidnapped. The evidence of PW4 is to the effect that he is the uncle. The uncle, no. Is that PW1 was his nephew. His evidence is all hearsay. Or oh, yes. Okay, PW4 also states that after he received information about the son of PW1 being missing, he informed PW1 that he had seen his son on the lap of the appellant. Mustafa, however, in his cross-examination, PW4 states that he did not tell the police that he had seen the abducted boy on the lap of the appellant, as the police did not ask him about the same. Mustafa. The evidence of PW5 is to the effect that PW1 was his brother-in-law. And that the incident took place around 3 p.m. on 17/7/2015. On the evening of the day of the incident, the appellant came to the house of PW1 and repaired his rickshaw. The appellant thereafter took away the boy to treat him with a chocolate. They were informed in the evening that the boy had not returned. For some phone calls were made to the appellant, which was however found to be switched off. Appellant's mobile, phone calls were made to the appellant's mobile, which was found to be switched off. Full stop. Thereafter, ransom calls were made for releasing the boy. Thereafter, ransom calls were made to the mobile phone of PW1, demanding ransom for release of the boy. The first demand was for rupees 50 lakhs, which was reduced to 3 lakhs. The PW1 thereafter handed over rupees 3 lakhs to someone. Thereafter, demand for another amount of 50 lakhs was made. Some 13 days after the incident, Chinmoy and Madhav apprehended the appellant and brought him to his brother-in-law's house. The appellant was beaten up and police was informed. Police thereafter came and took away the appellant.
Your Lordship, that's the small, your Lordship has said that the PW1 had handed over 3 lakhs to someone, whereas it is Chinmoy. PW1 in his statement says he has dropped it, and PW5 says Chinmoy has dropped it.
Oh, Chinmoy handed over,
So there is contradiction in this 3 lakhs also.
So PW5, also says that. Not
Chinmoy.
Chinmoy had that. Chinmoy handed over 3 lakhs to someone.
So there is contradiction in there.
But PW1 says otherwise. He says that he put it in some trees, among some trees in the Karegaon road.
So the veracity there also there is contradiction. So the
No, now it's raising a doubt as to whether this case is genuine at all. Why should he not be acquitted? PW1, the father says he went and dropped it among some trees in the Karegaon road. Now Chinmoy says he handed over 3 lakhs to someone. Chinmoy not examined also. Yes, Kamal said. And this Kamal is the brother-in-law of PW1.
Happy part is there. Even kidnapping.
We-
is not true. Kidnapping part still remains unregarded.
Maybe. One thing is that he has taken away, that is true.
yes,
well,
that is, recovery is not proof from him.
No, that is one. Maybe there is something in between, we do not know. The problem is the evidence is bad, the cross-examination is even worse.
If 313 question has.
So
been
we
correct-
might,
If the 313 questions has been correctly put, if I may say so, then you could have given an explanation. Because whether in those 13 days, it was with him or not, still not proof. However, the owners.
that is what, you see now, speculating,
Spec-
of course, speculation has no role to play, but then it appears that this fellow used to always treat him, always come to the house, taking him away with the purpose of giving him chocolate. And there also the father had seen, father also allowed. I mean,
Only thing is that there is no explanation because the onus is on, otherwise slightly on him, to be fair, to give an explanation
Yeah.
what happened
No,
after,
that's-
after he had taken the.
Not three. PW1 Monos Mojuddar reported instructionally Sven Samanas Mojuddar on the relativity of the offense for ransom. His reply, it's not a fact that I kidnapped Monos for the purpose of ransom, but other person remains. For ransom is taken away, but kidnapping person.
What I mean is that worship, there is no question put to him regarding the recovery
Anyway,
and the detention. period.
okay, one more
But
thing, you're
only
right.
the
Yes, one more
onus is
thing, you're right. The appellant's counsel submits that no questions were put to the respondent number, to the appellant at the time of his examination under section 313 CRPC. With regard to the evidence that were adduced against him to enable to make an explanation as to enable to make an explanation with regard to the real facts of the case. Huh?
Recovery.
With regard to the,
Recovery. Kidnapping part is there.
no,
Recovery part is
not,
conditional.
Recovery is not proof only, actually, to be fair.
with regard to the case of kidnapping. Nothing. Anyway. Then, in his first examination, PW5 states that denies the suggestion that he did not tell the police that the appellant had taken away the boy to treat him a chocolate. And that his brother-in-law and him were having a meal. He also denies the suggestion that Chinmoy had not handed over. And that he also denied the suggestion that he did not state before the police that Chinmoy had handed over rupees 3 lakhs to someone. Or that Chinmoy and Madhav had brought the appellant, had apprehended the appellant. The appellant, the deposition of PW6 is to the effect that when he visited the Kokrajhar police station about a year ago, police obtained his signature on a piece of paper. However, he did not know why his signature was obtained. Next para. The evidence of PW7, who is the investigating officer, is to the effect that an FIR had been submitted by PW1 on 6:30 PM on 17/7/2017, stating that the appellant had taken his son for a walk and both of them had gone missing since then. He also stated that he engaged secret informers on several places and arrested some accused persons. On 30/7/2015. The appellant was apprehended while he was crossing a road along with the victim. But out here, the IO does not say that he apprehended the appellant. IO does not say that.
It comes in his cross-examination. He says on so and so while he was apprehended while he was going along the road. In his cross-examination, then.
Full stop. Full stop, huh? Continue. In his cross-examination, he further clarifies the issue by denying the suggestion that he did not apprehend the appellant along with the victim.
And your lordship, if I may
Just a minute. Yes,
No, your lordship, because the auto rickshaw was also seized there and there itself on the road. But as per the PW1 version, police came to the house. So into, because he says on so and so Anand Devnath was apprehended while he was crossing the road along with the victim, and the auto rickshaw was also seized, and driver was arrested.
full
And
stop. Next para. In his examination in chief, PW7 further states that in connection with also states that one auto rickshaw was seized and the rider of the auto rickshaw was arrested. How does this make, how does this? They were in the auto rickshaw. Maybe. Because this is the, nothing is clear. That's what I'm saying. The evidence is bad. The cross-examination is even worse.
Or something your law for the lordship.
Yeah,
It's very, everything is there,
okay.
but for places of all, the IO always demolish the suspicion. Is like. There, but last time here.
Uh,
Why have come for it, nothing for it, so we, the property on why there are the five and a half. Last is your experience, because please to put up. And she wants, it's also there.
But what to do, madam? Now, auto rickshaw, probably they were in the auto rickshaw, but then the evidence does not show that. Just says that in connection with one, in connection with what? In connection with the apprehension of so, or they were riding in the auto rickshaw, nothing is there. You cut that auto rickshaw part, huh? Cut that, huh? That's enough, that is. The last paragraph, the small one. Yes, yes. That's all, full stop, that's enough. I think beyond that, there's nothing. Full stop. Okay, we'll keep it judgment reserved because I've got single bench also, no time. I'll refer the judgment.
And part.
And. Para 13. Para 12, that's it. Para.
Basically, your lordship, the demand part has been demolished itself because of contradiction with the IO and PW5. Only thing, the onus is on him for the presumption.
We
part.
see, we've heard enough.
Yes,
Yeah, we're going round and round now. Judgment reserved.
obliged, sir.
May I please the lordship. Due to some personal difficulties, the engaged counsel DP Bora is unable to appear before your lordship. So the matter may be adjourned today.
Have you given we have asked you to make any affidavit regarding your liabilities, assets and liabilities? Good,
We have filed an affidavit also, my lord. Today
good.
morning, my lord.
Okay, so Mr.
H. Buragohai, my lord.
H. Buragohain, learned counsel for the review petitioner. Prays that he may be allowed to withdraw the review petition as he has received instructions not to press the review petition. Full stop. Mr. S. Bishwakarma, learned counsel for the respondent number 1. And Mr. S.S. Roy for response number 2, 3, and 4. Oh.
My lord, my shears. That's why I didn't want to interview.
So I was dictating to thin air.
My lord, I was about to submit, my lord.
Oh,
Yes,
okay,
sir.
okay. Mr. H. Buragohain, learned counsel for the review petitioner, submits that he would like to withdraw the review petition, comma, as he has received instructions that the review petitioner would not like to press this case. Full stop. Mr. S. Biswakarma, learned counsel for the respondent number 1, and Mr. S.S. Roy. Counsel for respondent number 3 and 4. Who's for 2,
For state, my lord. State of Assam, my lord.
3, and 4? Submit that they have got no objection to the said prayer. Accordingly, the review petition is dismissed as withdrawn.
My lord, may I make a small submission, my lord? In this regard, today morning, I filed an affidavit by the petitioner, my lord. So can there be an observation that they have also filed an affidavit saying that the review has been withdrawn? My lord? Just a one observation, my lord.
Why?
Because,
Why?
my lord, this review has been filed, but today morning only they have filed an affidavit.
Let it will come. I do not know. It might be under objection also. We don't.
Oh, my lord, but I have given a copy, and I have the filing number also with me, my lord.
Okay, just right. Miss, before that, after his prayer for withdrawal, no, he also submits that they said instructions have been received after having filed,
My lord, after having filed an affidavit,
an additional affidavit,
bringing on record, my lord, the development why we are withdrawing.
bringing on record new development. Full stop. That's all.
Highly obliged, my lord.
But what new
My
development?
lord,
This, are you trying to be too smart?
No, my lord, what happened? The tender process which your lordship had given in the order under review.
Anyway, okay, that's all. That's enough.
I'm deeply obliged, my lord.
Is that real finishing of sugar?
Yes, everything everything hinges upon you.
He's a star.
So we are interested in which one?
That's 800, I think. It will be petitioner land and the successful tender, 800,
Actually, you are the 800 one.
800, that's
But
why.
there are two repetitions here.
আরো নাকি আছে আরো কি হয় এটা কি হয়?
There is another repetition.
Yes.
There are two of them.
What is this? Karthik কি আছে?
So unfortunately, Mr. Didas has forgotten. He's appearing in two cases and probably charging only for one. Now he's going to make up his loss, earlier bills. Yes, see, now he's thinking. Now he's got to
Right,
tell us about
honestly.
the facts of the other.
Very,
case.
very honestly, my lord, honestly, I have not.
Ah,
191. 191. In the second case, 191. That's petrol pump is not there. Our petrol pump is not there at page 191. Page 191.
no, which
Your
petition?
lordship is saying this second 6183.
6183 is the second one.
Yes, second one.
So
First one, my lord, the letter.
6183 is this Patilada, Hiwi, within
Second and 682.
Para two. Is it?
6192.
Salisbury, this is 6183.
Yes.
Yes,
That your,
6192.
this is what you have submitted. This is what my learned friend has submitted. It is, your lordship has seen, this is 800. We just pointed out 800 only.
800 is with regard to 6192.
Yes, 6192. I'm talking, let us, one with this way, my lord, is your lordship wanted to know what is the distance.
Correct.
I told that it is 850 maybe, but your lordship wanted to know by a learned French. Now he has submitted 800 meters. So, my lord, then your lordship knows that it may not be feasible. This is one. So far as this matter is concerned, 6192. So far as the other matter is concerned, that is 6183 of 2022.
Ah.
Bipasa, no? Bipasa. That,
No.
yes,
6192 is which one?
61 Kobita.
No, just a minute.
Six 6192 is Kobita Bhai and 6183 is Bipasa. Bipasa is
No,
item-
out here it says on Salisbury, Jogi, Gopar Road, 83.
83.
That is, what is that is? Vipasa? What is that Vipasa?
Bipasa is item 1. And the report is in respect of item number 2.
How do you spell Vipasa? B, B-I, B-A, B-I-P-A-S-A. What is the full form of this?
Bipasa Sumim Alam. Bipasa is a name only. Bipasa Sumim Alam.
Your lordship, I just now I have seen. This, he has given a report before the court. Kindly
Yes.
see the report. First
Yes.
one,
Yes,
para 1,
yes.
location name. Distance Salisbury, Jokighoba Road, that is Bipasa,
Ah,
which is indicated 2.4 kilometers. Now, the second one, that is the Kobita Das, that is 6192,
yes.
which he has para 2, that's 800 meters.
I remember.
So these are two where your lordship was asking.
And we were dealing usually with.
With Kabita, your lordship was dealing with Kabita.
Kabita.
Kabita was dealing, but no, what he has submitted both. What is the distance? That's what. My lord, distance, what my learned friend has pointed, let me be very honest. Distance is not being recognized, I think, if it is correct. Distance. What is that feasibility is important. So what I am praying, let them to redo again. Your lordship has seen that so far as the 800 also it is not feasible. I don't know whether they are complying with, that is some Congress something, if I remember last time.
Indian Road Congress.
Indian Red Congress. 800, and that's what is indicated. But what? Without affecting them. Without. Let them do a redo it, because they have to do redo. Your lordship has seen the guidelines also. That guidelines your lordship has pointed out that both has to be, all has to be discussed in the guidelines, which goes against them. Guidelines. Guidelines in respect of their own guidelines, which they have submitted before the court. And lordship has looked into the guidelines and found that not only you cannot take a decision, decision has to be all the 3 oil marketing companies, their voucher, they have to take a decision. So I think let them do the homework, redo it. Don't touch the NIT, let it remain. They will redo it again. If redo, they find that feasibility is there, then I don't have a case. I don't have a case then. I am not saying that your lordship will set aside. No, your lordship will not set aside the NIT. Let it remain. Keep it remain as it is. If it abates, let them redo it, let them furnish the copy to us.
Yes, Mr. Council, you were the amicus in that earlier case?
Yes.
You are amicus. Where is that map we had looked into earlier? That
Which case?
drawing?
Kavita Das,
Yes,
that is 6192.
that Bipasa.
Bipasa or
I think
Kavita?
Bipasa, no, I mean Kavita. Okay.
Kavita, I think your lordship was Kavita.
Huh?
160. It starts from 167 and the drawing your lordship will find it 173. 173. That's your lordship is asking about drawing it, the 173. Eight hundred.
So the distance of Saini is how far? Saini service station?
Signing. From your my petrol pump or your lordship is asking about the proposed petrol pump.
From the proposed petrol pump.
Proposed petrol pump. about 6-7 hobo, 6 kilometers, 10. He got the information is 10 kilometers.
From Saini to the proposed,
Yes. And from my petrol pump,
to the
which is
proposed
existing, proposed is 800.
800 meters.
This is what
And AIE Valley Service Station of.
AI will come on after that. 3.7 kilometers.
And Saini is petrol pump by the IOC,
Yes.
is it?
Hi, Chinese service station is. I Valley is the Indian Oil Corporation.
Acha, AI, you are also, you are
Yeah,
you also
mine is
IOC.
also in-
Yes, yes.
Maybe my lord, not so important what I
Yeah,
felt
okay.
is distance. The feasibility is more important than the OL. So
But
if they can do.
feasibility
in
on what
respect of-
basis?
No, in respect of what is the earning, how they do it, how much, this is what they work out in work.
No,
working is
they
of-
are supposed to have a minimum of some 25 or something like that.
Yes, better, my lord, this is, they will do a homework. If they find, my lord, it is minimum, I'll be out, my lord, there's no question. I'll be out, and your lordship, I'm telling today, your lordship will not touch the NIT. NIT will not be touched. Why they find it to do difficult in
No,
redoing
no,
that? He has to do it. He doesn't do it. That's the whole problem. That's why your lordship is, he's a star, he is made.
Yes. Page 3, yes. Yes, huh?
If you take his little pump, also well, then they more.
More than 25 kiloliters.
Then there is a chance to one more well petrol pump.
That you do, he doesn't mind.
I don't mind, the 3 petrol pump, no problem. Imagine, my only,
No, his, you see, unfortunately, now basically his back is to the wall. So he's only wanting that something should be done. So don't find any ground, but Mr.
No.
What is there? Nothing remains actually.
no, it remains, my lord, it is, if you do, then no, I would have no case, let me put it this way. I would have no case if they would not have considered the other 2.
Ah,
I would have no
correct,
case.
correct.
What case I would have?
That is
So
the
the
only
court
thing.
would have said, sorry, you don't have a case. The case which I,
one
this
thing,
is
Mr.
what I am
Bhatta.
on, my lord.
You see, when you are considering the feasibility report, you are considering petrol pumps that are 10 kilometers
10
away.
kilometers, and don't consider it.
The nearest
meters.
one is not considering.
Why it was not considered by Alconer is there in by David Manson, if you take his petrol pump, then they.
That is all right, but then you see, no, it's like this, you're opening a pawn shop. Say, here in, where I'm sitting, you're going to open a pawn shop. Now, when you're going to consider how much you'll be making in a month, will you consider one shop that is in Pan Bazaar and another shop that is in Ujan Bazaar, and forget about considering a shop that is just in the gate of the High Court gate? Now, is that feasible?
The owner is the same.
Huh?
The owner is the same. The pump is the same.
So maybe, so what, but then you are considering IOC petrol pump.
They have to invest more money, but then it depends upon the return.
No.
They can't manage. So they have to invest.
I think we'll allow this, at least for,
Similar, what is the right kind of the biggest number, whether.
no right, in a way. That is there. No right. That is another ground, Mr. Dadas. Where is your right? No right of yours.
More legal injury.
No, my legal, I am telling today itself, I may not have a legal right. If you have not considered these 2 pumps, I don't have a legal right. No, what I am saying, you considered these 2 pumps, my legal right, I'll say what is my legal right. My legal right is number 1, you violated the OM and you're not considering, that's my legal right which I have, because I have a petrol pump. I am not an outsider. That's my legal right. My learned friend has argued again, he's saying, your lordship has done the whole exercise and is only what? Why my learned friend is, they are afraid of looking into my pump. That's simple and clear.
No,
right?
but one thing is right. He's also saying one thing, is that he appears to be right, because he says that, you see, only an aggrieved person can come to to a writ court under Article 226. And an aggrieved person means a person who has got a cause of action. And for a person to have a cause of action, some right of his, some enforceable right of his has to be violated.
Well, let me give a reply.
Ah.
I can give a reply,
Yeah.
your lordship. Number one, what is an aggrieved person? Whether I am an aggrieved person who has come to a court or not. What is my legal right to approach this honorable court? What type of, that's what your lordship is putting and my learned friend is putting across it. And this is what right you have got. Your legal right, some type of infringement has to be there. So why you are stopping someone to establish a petrol pump? That's precisely, my lord. Some pump they want to put it. My answer will be, my lord, I could not have a legal right, but now my legal right, my lord, accrues from a decision which they have now come to a finding regarding about 2 pumps, which they have looked into it. And they totally ignored. I don't have a legal right to come in and say before the court, this is what you have done it. Why my case was not considered? If my case would not have considered, I would have no case at all.
No, but you see,
Yes.
what you are saying is, if they had not looked at other petrol pumps, you would have no right.
No, that's my law. Then what is the meaning of an OM? For what purpose the OM has been?
But then
examined of-
unless the OM is enforceable.
And they have, I'll give an answer, immediate answer to your lordship. Why this OM is enforceable? Why? Because they have looked into the OM and they have looked into OM and they have done the homework so far as other 2 pumps is concerned. If this was not enforceable, they would not have looked into it. So that's why my humble submission is OM is enforceable. They have not looked into this particular my pump is enforceable. Otherwise,
Okay, what about the other aspect that the IOC you have made an agreement with the IOC
yes,
that you'd be bound by the terms of the agreement
yes,
made in the agreement,
yes,
and the IOC has not objected
yes.
to the your principal has not objected to the opening up of a new petrol pump.
No, that's IOC can do it, my lord.
What?
IOC is violating, IOC will be violating their own OM, which they cannot do it. That's, my lord, this oil marketing company.
You are bound by the IOC.
No, I am bound. I am
You-
saying
you are,
that I am
you are
bound.
the agent of IOC.
Yes, I am. But my lord, what my submission is there, I am bound by the terms and conditions. Let me put it this way. I am bound by the terms and conditions. But that cannot be in, my lord, going against a particular OM that has been set up in 2013, I think, 2013. How can they go against that OM, my lord? This, my lord, the basic concept was 3 oil marketing company will sit together and they will decide regarding feasibility. Then which, my lord, the Indian Oil Corporation himself is saying, they can't say we don't have any objection. The
No, but then-
petrol pump is given to me. Now they will not look into also. But I would not have no case, I would not come to the court if they would not have considered those are 2 other pump, which belongs to IOC. That petrol pump, which is
One belongs to IOC.
then,
It is both.
my lord. So why not? My case was not considered.
Anyway, this Chinese service station is IOC
Yes,
or the other one?
I Valley is I Valley.
I Valley is IOC. And the other one is?
Other one. No, the other one. No, that was same case, other case.
Huh?
One,
Who? Our means who? BPCL.
Mhm. Fine. And next case, your lordship is about 191 page of next case,
Just a minute.
191. Page 191 of next case.
Yes,
So 191, that's full.
so out here all the notice, NIT, all the same.
Oh,
It's
same, same, all same, all same. So 191, that's an IOC first, no?
Where is the drawing again?
191,
191.
that is, first is the IOC. One.
Yes,
And second,
second one is
HP, Hindustan Petroleum,
Hindustan,
Petroleum Corporation, HPC.
HPCL.
HPCL.
Okay, now out here, what is out here, the difference is 2 point?
2 point some kilometers. 2.4 kilometers.
2.4.
Yeah.
2.4, and what is the distance between IOC and the proposed petrol pump out here?
Which your 191.
186.
191 or 186, 191. A distance.
How much is the distance?
Or distance. 186 distance. 18, 18 will लिखा है, 18, and next one is 10. That's what it indicates, my lord, at page 186. Kindly see 186, 1, IOC. Lordship got it? That is what I found is somewhere is 18 or 10. Hmm?
From proposal 18 and 10. And 18 and 10 kilometers,
Yes, right.
and yours is 2.4.
Yes. All these consideration, they take 18, 10 minus 24, they will not take it. I don't know. This is makes it easier. He should have said today we'll go for again.
Yes, Mr. Botakur, what about that OM? Just,
Suppose man, there is a procedural last one out of.
no, I am just asking. Ah.
Not the same way, right? Public interest is involved in this.
This is a writ, this is a writ court. We're not looking at public interest.
That's why I'm.
We are only looking at whether there has been some interest, private interest that has been.
Yes, fine. Two of the meetings, but
No, what the senior counsel has said is that this OM has to be applied. OM of 2013.
that's why I'm submitting.
Ah.
Maybe there is some procedural lapse or error in assessment. That is matter the gives them a right or legal right to silence our feasibility report.
If you're supposing the OM has told you to do certain things in a certain way, why shouldn't you do it as it has been stated?
That's why I'm submitting. Even if there is some error in assessment, but then other human right, legal right to silence our feasibility report.
No, because he's
Guidelines,
no. OM is only a guideline. Yes. Yeah, yeah. Huh? Broadly speaking, yes. Yes, Mr. Didas.
I think these judgments, my lord, have shown that's a proposition law laid down. But here he himself violates his own OM. What my learned friend has said just now, procedural. This is not a procedural. How can he proceed? That's a basic requirement they have to carry out. Only 3 oil marketing companies. This is not a procedural. What my learned friend said, procedural lapse. There may be a procedural lapse. This is not a procedural requirement. The requirement, that's what the OM has given.
No, but what this says is that if any instruction, any memorandum or whatever, does not use the word memorandum, but it says any instructions or anything. If they have to have some statutory force, the source must have statutory force. It has to be made on the basis of some statute.
Now there is no rules. There is no rules has been made under any of the act. So what they brought it by an OM. So it is not that a replacement by way of a supplement. They supplemented. There is not supplement. But they have admitted, they have done a homework, and today they are saying, no, I will not do that petrol pump. I leave that petrol pump. This is what my learned friend is saying. It is up to us. And suppose the rule comes, then of course, my lord, the OM may not be in value. If it is, my lord, your lord said that's the law which has been laid down by the apex court. But unless it doesn't come, why that OM has been issued?
Anyway, so this feasibility study, once it is done by, it doesn't have to have the approval of anybody. Not required. Not required, correct. Anything else? So even if we say that, okay, you do it and then you pass orders, what is there? Anna? The thing is that you see, there is some method applied for coming to a decision whether the petrol pump will be feasible or not. But the problem is that you have considered petrol pumps that are very far away. And not his petrol pump. He is scared that he's scared that his business will be affected and probably will be affected.
No, they know. I'm not saying.
No,
It
you
is
also
affected.
know. It is not that you don't know.
No. What is my effect?
Huh?
No.
Ah.
No, affected. You have considered 10 kilometers and
And
you are giving.
that is a business thing. How does because there's another aspect to that matter. Now, even if it affects your business, so what is the problem? What is our problem? If the consumers, if the general public at large are going to be, is going to benefit the general public. Public, correct. Now, how can
My
one
learned
person?
has given a pump to us, and today he say, because their job is done, their job is done. At the time, I know all these companies, my lord, honestly, let us forget, they come and they say a lot of things, we'll give all this validity. Once it is over, my lord, they forget everything. Now they want more pumps, they forget about the oil marketing, that vouchers they forget. And today they are saying there's not required. More pumps, the more merrier, more business. Absolutely no problem. But please consider my case. If you feel that I don't have a case, then okay, you reject it. I know where I stand. Unless I will not trouble the court. I came only for that reason only. Some 10 kilometers you consider today, Indian Oil Corporation should say in the open court, okay, it has not been considered. Why my learned friend is not saying? He has said, their own officer has said that yes, it has not been done. And today he is saying that this is not, I think this is not done.
Okay, one thing.
Yes.
For the new pump at that in Bipasa, what is the feasibility report? What is the kiloliters that is expected?
Yes.
Sale that can be. No, 25 is the minimum, but as per the feasibility report. 63 kiloliters per month. Per month average. And for the other case,
Other. Give report.
one zero six in Bipasa.
Yes, sir.
106 per month.
Yes.
What was it?
And in the other one, in 6192,
What Pali?
in Kabita Das. You please check, he might be giving me wrong
No,
figures.
this is a part of,
63.
this is a part of record. What was it? Yes. So this one, where is it? No, where is page? Page. 180. Kabita ne Bipasa. 173. Kabita na 173. 173. You are lying down. You have not considered our part. You are taking other palm. How can, where is the evidence? I know that you can't do. My lord, that's what, how can he do it? Two pumps, not mine. Whatever the other pumps, which is 10 kilometers, he's calculating that.
Absolutely, that's
Yes.
no, that's what I wanted to know.
Yes.
I wanted to know, after calculating those two pumps,
Yes.
what was the average turnover that he was expecting for this thing? So in this Bipasa case,
Yes.
106 kiloliters, and for the other 63. That is
Other
without
case-
considering your case.
Other case, without considering my case,
Bipasa mein they are getting 60 KL per month.
60 KL per month. So how does, no, that is a different thing. I'm not on that. Now, but for the new pump in Bipasa, without considering his case, but considering the others, you are going to sell 106. Correct? And he was selling 60 KL, according to you. Now, that is not in the report anyway. So we do not know. Now, with regard to the other one, this Kabita, you are expecting 63 kiloliters. Average turnover per month, after considering the other two pumps. That's all I wanted to know. So, okay. Actually, He's worried about that. He's worried about his basic worry is that only. But there's only one problem, like thinking about everything. You considered petrol pumps that were far away, you didn't consider the petrol pumps nearby. That's all. Huh? I know. Even if you'll still come 25. You'll come, but then you'll consider his case, that's all. We'll write down everything. His sales are getting affected. Sometimes you've got to go, sales are getting affected. His annual turnover might go down to below 25 or so. How do you know? Huh? Because you have to make in your feasibility report. You have got to also, I think, consider how much he will have to make. Because once, supposing you take away all his business and his turnover comes to less than 25 kiloliters, then what happens? Correct. 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 You install 20 pumps also. You do that. You do that. That's all. You do that. Anyway, let us see. I mean, the law is there. Where is the OM? OM is at page.
Yes. OMMs. 6183 is 167 in 6183. 6183 Vipasa is 167 at the same OM. And in other case is 148. That is 6192 Kabita Das.
148.
148 and
6192.
6192. And in this Vipasa is 167. Oh, that's it. Right. तो वही मैंने तो पर्सन अकाउंट भीतर होगा भीतर होगा ओ ये तो देखा ही देखा है सो
Acha, in Kapita, Saini service station was how far away?
From the petrol pump is 800 meters.
No, that much I know. Saini to the proposed petrol pump, 10 kilometers. And from A Valley
3.7 kilometers.
to the proposed?
Yes.
3.7.
That's what he doesn't want to do. They will not affect. 10 kilometers may affect them. 10 kilometers, that will not affect. 3 point also will not affect. 800 meters, which are, that's why they have not done this homework. Right? Others, they have done it.
Okay, right. Para? Okay, anyway, right. So I'll just do hodgepodge because I don't have time also.
Yeah.
Where's the OM? In 6183, where is the OM? 66.
Actually, your lordship has recorded once.
I've recorded,
yes,
but
yes.
I've got to fix, I've got to then again join it up. So many, they have just arrived yesterday evening. So, those, I've got to trace out all those papers. Yes, page 163, 63.
Our OM might
Yes, your OM is at page 63
56 minutes are in Kobita.
in Kavita. 66
That's not the limit.
in Kavita, you mean? Oh, in Kavita, okay.
Kavita is here, okay.
66.
That's not the limit. No.
Where is the important portion? Huh?
Identified by the electrical based on the commercial minimum order concept.
Where, which page?
Page 66, madam, identification of location,
Yes, yes. yes.
how it is to be done, madam, it is our internal guideline.
Here. Where? Page? Second page, yes, yes, okay. Now, where is the OM? 2013 OM, that's what I'm
That's what,
saying.
that's what your lordship is 148 in Kavita does. Kavita does 6192 of 2022. 6th of April 2011. 148 in Kavita das case.
Okay, just read, right, huh? The Government of India, Ministry of Petroleum and Natural Gas issued a letter dated issued letter number P-19011/5/2010 dash IOC dated 6/4/2011 to the Chief Executive Officers of BPCL/HPCL/IOC regarding the new criteria for conducting feasibility studies for new retail outlets / preparation of new marketing plan. To be followed by the oil marketing companies as reflected below. Page 148. 1, 2, 3, 4. Okay. Next. The guidelines on selection of dealers for regular and rural retail outlets through draw of lots / bidding process as provided in the brochure in the brochure for selection of dealers. No, don't say that. Don't say that. Bidding process as published on 24/11/2018. Provides for identification of locations. Full stop. Para 1, full stop, A capital, full stop, provides the location for setting up of retail outlets as identified by oil companies based on commercial/minimum volume considerations. Full stop. The applicable volume norms are as under. 1, 2, 3, 4. That's all. Full stop. Next paragraph. The case of the respondents number 1, 2, 1 and 2, 1 to 3, 1 and 2. Mr. Bhattakur, here for 3. The case of the respondent number 3 is that the retail outlet pertaining to the present cases are in respect of rural retail outlets, bracket E class, wherein the expected combined sales volume of petrol and diesel, correct? Petrol and diesel was to be 25 KL per month. In terms of the feasibility report made in connection with WPC 6192 of 2022, the expected combined sales volume was to be how much for the Kabita? Was to be 63 KL per month in the proposed new RO. Full stop. In respect of the new proposed RO in WPC 6183 of 22, the combined sales volume, the expected combined sales volume was to be 106 KL per month. Huh? I am not on that. I am on the new petrol pump to be made, to be set up. How much was the expected sales volume of that? That's what I'm talking about. In Kabita, what was the expected sales volume of the new RO? 80. Instead of 63, it will be 80. Huh? Whatever. It will be 80. And in that and in the other one, and in 6183, how much would it be for the new proposed RO? $55. Got it. Next. On perusing the next paragraph, on perusing the documents, on perusing the pleadings in WPC 6192 of 2022, it is seen that the respondent number 3 had made the feasibility report by considering Saini service station bracket BPCL. No, they say under the BPCL, comma, which was 10 kilometers away from the proposed new RO. Full stop. No, comma, while the distance of AIE Valley service station, comma, which was under the IOC, was 3.7 kilometers away from the proposed new RO. Full stop. The petitioner's petrol station, which was 800 meters away, was not taken into consideration by respondent number 3 while making the feasibility report. Full stop. Next paragraph. In WPC 6183 of 2022, the feasibility report made by the respondent number 3 in respect of the new proposed RO shows that the feasibility report was taken into consideration, taking into consideration Hulas Chand, Hulaschand, Chand, Sarawgi, SARAWGI, and Sons, bracket, not bracket, comma, under the IOC, which was 18 kilometers away from the proposed new RO, comma, while and Jaggi Kopa service station, which was under the HPCL, that was 10 kilometers away from the proposed new RO. Full stop. However, the feasibility report did not take into consideration the petitioner's petrol pump, which was 2.4 kilometers away. Is this correct? These are 10 kilometers away and 18 kilometers away you took into consideration. Is it correct?
This is. That's 18. Very short. I bit of doubt is there. 18. I don't know.
It's a 1.4 kilometer
Which one is 1.4?
from
From Hulachan is 1 point, instead of 18, you write 1.4 kilometers. And with regard to Jogi Gofa,
No, he's wrong. It's, I think, 18 kilometers. Kindly see 191 page. 191, there's a drawing. Their
And-
drawing,
191, yeah.
191, see that. See, my lord, Indian Oil towards Boigaon, kindly see this, my lord, 1. To the intersection, 10 kilometers. They have written 10 kilometers. And from intersection to this, 8 kilometers, so 18, that's why they have said 18.
But where is the new where is the new proposed RO?
New propose is here. P is proposed at page 191. On top, P is proposed.
Acha,
P
please.
is proposed. So from this IOC 1, your lordship will kindly intersection 10 kilometers. Go above 8 kilometers. 10 plus 8, 18.
Okay, yes,
That's
correct.
18.
Yeah, 18 and 10 is correct.
Yes.
It should be 18 minutes.
18 and 10, correct. Yeah, correct. Then what else? Anything else? Any other fact? What fact? Okay, you take this down, this portion, huh? Just give it to him. Let him, because I think they want the book. You want the book back? Later on. Then we've got no time now. Huh? Oh, okay, right, yes, right. Learned counsel for the point number 3 has also relied upon the judgment of the apex court in 2016 8 SCC 622 at para 43, and in the case of 2007 8 SCC 212 at para 19 and 20. Getting concluded, judgment reserved.
DPO. DPO. You are not leaving at last, he said. He fought, that's why. DPO.
He has to fight,
Yes. of
and
course.
he has got fighting points also.
That's what I said.
What is this IA? Yes, what is this IA?
My lord,
Fishery.
it's an application leave of the court, my lord, to file a review petition, my lord.
We were not made party in it.
We are not,
We'll issue notice.
actually, we are not party in the.
Will issue notice. Will issue notice.
Only one thing, my lord, already pursuant to the order of the honorable court, my lord, the department has already floated a tender.
20th of July.
28th of July is the last date for submission of,
22nd of August.
or 27th of August.
22nd.
22nd of August is the last date.
Then you serve them copy by dusty service, the Debru Dangori part 1 means Sabai.
Yes,
Then we list it before 27.
my lord, 22nd is the last date for
Maybe,
submission. of
why do you
tender,
come
my
at the
lord.
last minute?
We have not come last minute because we filed on 26/6/23.
26/6.
Yes, my lord.
Then what happened? 26/6, so we were all here.
We are pursuing in the office, my lord. I don't know, a review petition, they
Ah,
keep it pending.
We do not know.
But there is no
No stay.
effect and nothing, my lord.
No stay on the first day, madam. You're first of all, you're an outsider.
Outsider, my lord.
You, right. Heard Miss U Barwa. Leonard's senior counsel for the applicant who submits applicants. No, applicant. Applicants.
Applicants. Who are
Applicants. Who submits. Where is the order under challenge also?
Review is.
You're put it here.
It's a review, my lord.
So what? But you should put something here. You'll only want to save money, photocopy.
In the review petition, my lord, its order is there.
Who submits that
In the report.
applicants may be granted leave to file the review petition against the order dated 15/5/2023, passed in WPC 520 of 2022. In as much as they were not parties in WPC 520/2022.
And in fact, my lord, the another writ petition we filed, my lord, with opposite prayer, my lord, to close down the fishery itself, my lord. That is pending, my lord, and that it was known to the government department as well as the forest department. They did not point out why the case was taken up by the
Where,
one.
which is where? Kara, page in the.
Page 16, my lord, of my 60, my lord.
60.
This case is pending, my lord.
No stay given here.
At that time, my lord, there was no proposal to float the tender, my lord. That's why to this, Mr. D. Gogoi, learned counsel for the respondent P5 and 8 submits that. As of now, nothing has been done. Taking into consideration the sum, the court is at present not inclined to pass any interim direction, however.
Then,
Liberty is granted to the petitioner.
why should your, where is the, why should the review petition be allowed? What is the ground?
Your lordship may kindly turn to page 83, my lord. It is a letter from the DFO to the deputy commissioner. Even before that, my lord, while the case was pending before the honorable court, the department has called for a report from the DFO. He has submitted the report and that has been annexed to the affidavit filed by the government, commissioner and secretary to the government. That report of the forest department that is annexed
With
to
issue
the
notice on the right. What have I said? Issue notice. Today's what date? 16th. Returnable in 1 week.
my lord, may I pay date may come up on 21st. In the meantime, we will take justice.
Okay, issue notice. Just issue notice, that's all. Mr. S.S. Roy, accept notice on behalf of.
P 4, 5, 6, 7, 8, 5.
Huh?
P 4, 6, 7, 8, 9, 10.
Okay, Miss S.S. Roy, of course, so and so. Then Miss G. Azarika for point number 5. What about 11? Who is the penny of forest? Mister? Who do we say? D. Gogoi. Huh? B. Gogoi. D. Gogoi. Accept notice on behalf point number 11. Applicants shall serve notice upon the respondent number 12.
1, 2, and 12.
1, 2, and 12. Through dusty service.
Yeah.
Within 3 days. And file affidavit of service thereafter.
My lord, may I pray that the matter may be listed on 21st?
If you file, if you and send full stop, the applicant shall also file affidavit of service.
Yes.
Showing that notice has been served upon the applicant. If affidavit of service is filed, then the matter may be listed on 22nd. 21st Monday, tomorrow is the only day you have got. After that, Friday, Saturday, Sunday holiday. If you do not file it by Monday, no order will be passed on 22nd also. I am giving you that guarantee. I'm giving the guarantee. If you do not file your affidavit of
No, I
service,
will definitely file. I'm grateful to your lordship, madam.